Let's bring in NBC 10 legal expert and dean at Massachusetts School of Law, Michael Coyne. Michael, another day, a lot of motions, but Judge Cannone really only ruled on a few things in court, specifically a loss for the prosecution. They wanted access to a very narrow but communication between Yannetti, who is Karen Reed's lawyer, and Karen Reed. That's usually attorney-client privilege. Prosecution was saying, oh, but she erased that as soon as she started talking publicly about this one narrow lane they wanted to talk about, and Judge Cannone said no. Just your thoughts on whether they should have and how hard that is to try to break that confidence.
It was a bit of a reach. I'm not surprised she denied it. She really should have. We protect the attorney-client privilege in Massachusetts to the greatest extent possible. We want clients to be able to communicate with their lawyers effectively, tell them the information, knowing that that information is taken beyond the grave. The attorney will not release that even beyond the client's grave. In Massachusetts, we have a clear decision in that regard.
All right, let's start where the day started, the third-party culprit defense. The Commonwealth does not want this to be allowed. Brennan says it is unrelated to the case and character assassination. The defense believes the evidence shows consciousness of guilt, and they point to Brian Albert, Colin Albert, and Brian Higgins. Has the defense made the case, made the argument to allow a third-party culprit defense?
They've made the argument. The question is, will they be able to establish an admissible foundation for the defense? And that's what they're really arguing about. Brennan is saying a lot of this is based on conjecture. It's based on character assassination. Where's the beef? What evidence specifically do you have to support, A, that he was in the house, and B, that they had a motive and the means to kill him?
Is it a high bar?
It's not a high bar. Massachusetts encourages the use of the defense, but there has to be some factual basis through admissible evidence. And I think that's what the court's likely to do here, is to say they can present it as long as they provide the proper foundation first. And so they may not, again, be able to use it in their opening statement.
I'm going to put a really quick pressure on you because we don't have a lot of time, but what is the difference of naming them as third-party culprits? Because didn't we all get the understanding they were saying it without saying it in the first trial?
Yeah, I do think it was a lot more subtle this time, but what Brennan is forcing them to do is you can't just do it subtly. You've got to provide the evidence, the support for it, because otherwise it's just leading the jury astray.